Hello, everyone, and welcome to the Legal Helm, where we explore the evolving intersection of law and technology. I'm your host, Bim Dave, CEO of Helm 360. Today's guest is someone who sits at the intersection of legal expertise, technical acumen, and business strategy. David Carstens is a founding partner at Carstens, Allen and Gourley, and a nationally recognized authority in intellectual property law. With 2 engineering degrees, a law degree, and an MBA, David brings a rare multi-dimensional perspective to IP strategy. His clients span industries like technology, medical devices, telecom, and cosmetics, and he's known for turning IP into a competitive business asset. It's a real privilege to have him on the show today and to explore how legal strategy must evolve in the age of AI digital transformation and the 5th industrial revolution. David, welcome to the Legal Helm.
Thank you very much, Bim. It's a pleasure to be here.
So, as I mentioned in your intro, you've had a very interesting educational background and career to date. Maybe you could just give us a little intro in terms of the journey that's kind of led you into this space.
Sure, I'd love to. So when I was growing up, I was always fascinated by technology, even as a young kid. And consequently, I thought when I went to college, maybe I would study engineering. And so I did my initial degree in mechanical engineering, which has always been probably my first love, just the ability to design stuff, build stuff, understanding materials, understanding thermal properties of materials, just always has fascinated me. But I also want to understand a little bit more about how people go about protecting innovation. And so from that undergraduate education, I went on to law school, and with a focus from the very beginning to go into intellectual property work, understanding patents, trademarks, copyrights, and trade secrets, because I thought that that would be a fascinating career, and it has been.
Amazing. No, it certainly sounds that way. So with that kind of interdisciplinary background, how has that helped you anticipate or navigate some of the kind of waves of technological disruption that's been happening in the market over the years?
Well, it has, because we've been living through some rapidly changing times with regards to technology. I recognized that when I first got out of law school, even I realized, gosh, my first engineering degree was a good start, but maybe not enough. And so I actually went back and finished up a degree in electrical engineering as well, because I thought there's so much change in the space, especially around computers and so forth, that I simply need to be more equipped to understand. So much of what we do in intellectual property work is we're having to deal with new and novel inventions. And the quicker you can get up the learning curve, where you can actually talk to the inventors and understand what they're doing, the better. And it's hard to do that if you can't speak their language. And so consequently, the second engineering degree was particularly useful.
Yeah, no, amazing. Sounds like they were very, very helpful in where you've ended up. So I believe you've recently been lecturing on the 5th industrial revolution. Maybe you could start us off by framing what it is. How is it different to the 4th?
Sure, sure. I'm always fascinated by the way technologies evolve, sometimes in fits and spurts. And the 5th industrial revolution is a phrase we use for some of the latest technologies that were going to transform our economy in what I consider a very revolutionary way. And so, for instance, we look at technologies like AI, blockchain, quantum computing, virtual reality, and in some level, advanced materials as kind of the 5 driving forces behind this new industrial revolution. Now, a lot of times people will say, well, yeah, how are we already up to the 5th? When was the first industrial revolution? And so love to chat about that even for a second, just because to give you some context about why I think things are going to change so rapidly.
Yeah, please. I'd love to hear more.
Yeah, happy to. So sometimes people will talk about the first industrial revolution as being something that was driven by the improvement of the steam engine by James Watt back in the 1780s. James Watt was in England. He was actually Scottish, but he did most of his work while he was in England. And the steam engine had been around, but had not been very efficient and not very effective. He studied it and came up with a dramatically improved version of the steam engine. And this revolutionized the way factories operated in England, because it suddenly became a viable substitution for human physical labor. And over the next 60 or 70 years, it transformed England's economy. And the nice thing about that was, of course, it made England very powerful, and it also made England very wealthy, because it became a manufacturing superpower of the time. The second industrial revolution really started occurring here in the United States, and it was driven by men whose names you probably already know, Westinghouse and Edison and Tesla. And their thoughts were around the ability to generate electricity and simply send that electrical power over lines to factories, but also to homes, which was new. And so that second industrial revolution occurred really around creating electrical grid systems. And that took a long time, but over a period of 40 years or 50 years, it transformed America's economy. The third industrial revolution was really driven by men who worked in electronics. And so, for instance, you might remember old vacuum tubes being used for amplification. Well, the real revolution occurred when a man named Shockley developed the transistor. And the transistor acted both as a switch for electricity as well as a means for amplifying electrical signals. And I have to give a shout out to Jack Kilby here from Dallas, Texas. Jack developed the integrated circuit. And both those men, of course, won the Nobel Prize for their work. But that was really the basis for what I'd call the third industrial revolution, which was what do we do with electricity now that it's in homes? How do we manipulate it to do useful things? And of course, there were secondary things, televisions and radios and so forth, but really it was the underlying electronics that made those things possible. The fourth industrial revolution is really what we've been living through. Bim, I'm sure you've watched the fascinating evolution of the internet, the widespread adoption of computers, the ever-increasing sophistication of computer software. And you've seen the amazing productivity that's come around from those technologies of the fourth industrial revolution. The nice thing about those second, third, and fourth revolutions was they primarily happened here in the United States. And it's one of the reasons why the United States is the economic superpower it is. These are revolutions in the truest sense, that they turn over old ways of doing business and replace it with something new. So here we are at the fifth industrial revolution. And I think everyone kind of senses it's happening because we've seen what AI has already done in the last year. 3 years ago, people were kind of still talking about AI as some future thing that might be useful. But once ChatGPT came out and Grok and some of these other useful tools, I think everyone is amazed at how good they are. And as good as they are today, imagine what they're going to be like in 3 years. They're going to be even better. So that's why we believe that we are already in the fifth industrial revolution.
Yeah, it's a fascinating history, and it's kind of interesting because I've obviously kind of grown up in the fourth and seeing into the fifth, but it's quite interesting that even just basic things like when I started my first job, the way we would access information, like technology information, would be in a series of books, right? So we would literally have a little mini library with lots of programming manuals and things like that to go and get an answer to a question. So you would take time to go research and then go get an answer. And I'm sure it's the same for you in the practice of law. But just being able to explain that conceptually to like my 8-year-old child who's in a completely different generation is pretty interesting, right? Because she's like, why do you need to look in a book? Like you can just search on Google or wherever. So it's
I worry about it a little bit with my kids because I don't know if they even know what an index in a book was. We used to have to go to libraries and find the books on the shelves, flip through the indexes, and then try to figure out, okay, well, it's on page 243. Okay, well, I start going through that. That was I don't know. Sometimes I think that those kind of scholarly skills should still be taught. I worry that sometimes information is a little too easy for people to find. And I think it doesn't develop some sort of certain critical thinking skill that forces you to pre-filter the way you go about searching for stuff.
Yeah, indeed. There's definitely something to be said for that. It would be interesting to hear from you in terms of like how, obviously you've been lecturing, I believe it's SMU.
SMU Law School,
yeah.
almost 30 years.
T- Yeah, tell us a little bit about that journey because it'd be interesting to see how you see, even just the way that you're teaching and the things that you're teaching over the years have probably changed pretty dramatically as well.
Yeah, yeah. No, I've always enjoyed teaching. I graduated from law school back in 1989, and in 1992 I started to go back and be one of the adjunct professors at SMU Law School. Initially taught patent law, and then for a couple of years I picked up a class called Legal Protection of Computer Software. It was a very focused type of intellectual property course that was just looking at the specific issues around how do you protect software. And at the time, in the kind of mid 90s, that was a fascinating topic because the software industry was blowing up in America. It was becoming bigger and bigger, and the questions about how do you keep people from taking innovative improvements made by other companies really came to the forefront. And so consequently, how do you patent computer software? How do you go to the limits of copyright protection in software? Where do trade secrets and trademarks fit into the protection scheme, the protection strategy? Was a really interesting and evolving, rapidly evolving area of the law back in the mid 90s. In 1995, the Patent Office came out with some guidance that kind of settled a lot of issues, and consequently, it became less of an intriguing issue for me. So I moved on from that class and started teaching international IP law because we were seeing in our own practice this rapid acceleration and globalization. And what I mean by that is we have clients who suddenly were selling products overseas, and they were more and more interested in getting patents in Europe and in Japan and in Korea. And at some level, they even were starting to want to patent their stuff in China. And so for the last 20 years or so, I've consistently taught international IP law, which is, again, just a fascinating topic as you see how the world has also evolved in its understanding of intellectual property and its value.
Yeah, no, absolutely. Do you think that legal professionals need to develop new skills in this era? So things like data science, ethics, policy interpretation, just so that they remain relevant with things changing so fast?
Yes, I mean, I thoroughly believe everyone always needs to be on a journey of constant education. And so it's not just attorneys, but since attorneys are entrusted with client matters and clients have to, have faith that their attorneys are current on topics, I think it's important that attorneys constantly educate themselves about the limits, particularly of AI. I think there are already kind of anecdotal stories that we hear regularly about attorneys who, when pressed for on a deadline, will simply let an AI servant generate, for instance, a brief they file with the court. That's playing with fire. And obviously, some attorneys are already getting burned when it turns out that the brief was not very good at all. In fact, maybe hallucinated and made up cases and such.
Yeah, yeah, absolutely. Yep, you got to be careful.
Yes.
What would you say from a law firm perspective, what should they be doing now to kind of stay ahead of the curve when it comes to IP strategy in particularly in like tech heavy sectors?
There are some fundamental how to say this, not drawbacks, but there are some fundamental hurdles that have to be acknowledged when coming up with IP strategy. The first is it is always a little uncertain how the patent office will respond when you apply for something in the field of software implemented inventions or something around AI incorporated inventions. And so you may have a very good strategy, but find that the patent office does not cooperate with that strategy. Another aspect of any strategy is understanding who your real competitors are and keeping an eye on what they're doing. How are they creating a moat around their processes? How are they potentially blocking you from doing what you want to do, which your client wants to do? And so it's important to always be thinking in terms of what can I actually protect? And more importantly, what are my competitors already protecting?
Yeah, yeah, no, indeed. And just getting into some of the kind of IP strategy, particularly in the age of AI and blockchain, like they are fundamentally like reshaping the IP landscape, right? So, what
Yes.
do you see as the most pressing risks or legal challenges now for firms and IP holders?
I'd like to start by talking a little bit about the types of intellectual property. And I talked about patents and trademarks and copyrights, but keeping in mind that those are fundamentally different types of intellectual property. Patents would be something we'd use for inventions, new methodologies. Maybe that methodology is implemented in blockchain. Maybe it involves some sort of an AI aspect. Copyrights are used to protect written works of authorship, which might be software code. Trademarks might be your branding. How do you go about branding your products and services? And then trade secrets are how we protect information that may be technical, maybe it's business information, but it's information that has value to your company because you have kept it secret. It's not generally well known and you've taken reasonable precautions to keep it secret. And so every good strategy has to kind of look at all of those aspects. Now, when we talk about patents, one of the biggest risks is you're communicating what are very, very cutting edge, complex concepts to the US Patent and Trademark Office, or perhaps the European Patent Office or the Japanese Patent Office. But in every case, though, you're still dealing with a person, human being, who's an examiner at one of those organizations, who may or may not really understand what's the core of the invention. And so one of the very first hurdles is simply being able to effectively communicate what is the invention. It's easy to throw around lots of buzzwords, but at the end of the day, you have to paint a picture that's so clear that an examiner at one of these patent offices can review it and in just a few hours truly understand why it's unique. That's the first hurdle. The second hurdle is every one of these organizations around the world view things in a slightly different way. The US Patent Office is driven by its own internal policies on how it examines these sorts of cases. It's driven in a large part by the law established by federal courts. In other words, while there is a statute, patent law, that statute has been interpreted by federal courts, including the US Supreme Court. And so, for instance, in 2014, there was a famous case, the Alice case, that came out of the US Supreme Court that dealt with how do you examine cases involving software implemented business methods. And the case caused a terrible disturbance at the patent office because of how the holding was written. And they had to redo their entire examination process according to what the justices of the Supreme Court told them to do. And consequently, allowance rates at the patent office for those sorts of cases went from 70 and 80% allowance rates down to about 5% allowance rates. Fundamental shift in how cases were examined. Likewise, when you deal with the European Patent Office, it has its own set of thoughts and procedures around software related cases or AI related cases. And so the strategy has to look at individual patent offices and how that affects your overall global strategy for creating protection.
So, is it fair to say that like traditional IP strategies kind of have to evolve because I think they're probably built more for tangible innovations, right? Physical things that you can touch, see,
Absolutely
hold.
true. Absolutely
Yeah.
true. The patent office has never had an issue with tangible inventions.
Mm.
Something where it's easy to look at it, easy to conceptualize what it's doing. Physical apparatuses, that's the patent office is spectacularly good at those sorts of cases.
Mm.
What the patent office does, though, and it evolves, it understands the challenges it's facing. And honestly, I think the U.S. Patent and Trademark Office does a remarkably good job of handling an incredibly difficult task. You're asking an organization within the federal government to make an assessment within a reasonable amount of time about whether something is novel, whether it's inventive, the scope of the protection that should be granted to a particular invention. And every one of the cases is brand new and different. And hundreds of thousands of cases get filed every year. Now to do that, they have grown. There's about 8,000 examiners at the U.S. Patent and Trademark Office. Every one of them has got some sort of a technical background, and then they get clustered in what we call technical centers. And there are approximately 9 technical centers. One of them, is focused mostly on electronics. Within that group, there are subgroups, and those subgroups are clustered around types of technologies. And so consequently, there is a lot of specialization that occurs at the U.S. Patent Office to help them deal with this rapidly evolving technology landscape. And so for example, Technical Center 3600 is what we call it, is around electronic commerce. And within it has various subgroups that handle different groups of, sorry, I'm kind of rambling here a little bit because it's hard to explain how the technical centers are designed. But technical centers are the methodology that the Patent Office uses to make sure that the best examiner gets assigned to whatever case arrives on their doorstep.
Yeah, no, makes sense. So I'm just thinking about some of the products that we're seeing kind of being launched into the market at the moment, where it's really a blend of two things. It's a device, or it's a physical product that has now been infused with AI. So, example, I recently got a pair of Meta glasses, right, AI glasses,
Oh,
and
good for you.
uh,
How do you
yeah,
like
and
them?
and they've actually surprised me. So this is the first time I've needed to wear reading glasses, right? So I went to the store to go and pick up a regular pair of glasses, and I looked at the price of the ones I liked, and it was basically the same price as these ones. So I thought, I'm a tech guy. I want to explore the technology, so I tried them on, and they're super light and work well. And yeah, I've actually ended up using them more than I thought I would for things that I didn't expect, like taking pictures and listening to music on my commute to work and stuff like that, and even telephone calls. And it
Yeah.
does a very good job of it. So that blend of physical product and then AI being driven into those products to be able to produce something else. How does that play out in the world of IP, in your world of IP strategy? Because presumably,
Hey John, how do I find out what we've invoiced my client?
How can I view my outstanding WIP?
How do I submit my expenses again?
Do we have next Monday off?
Monday off?
It's exciting to have fresh faces at your law firm, but onboarding them takes a lot of time and a lot of energy when everyone is remote. You're busy enough as it is. Helm 360 has the solution. Just ask Termi, Helm 360's next level chatbot solution for knowledge management. Termi can answer many of your new hires' questions for you without distracting you or anyone else at the firm. This means fewer frantic emails, fewer help desk tickets, more time and more focused productivity for everyone at the firm. Working with Termi, you can have those eager new employees up to speed in a snap. They may never need to ask you a question again. Check out helm360.com/Termi to see Termi in action and find out how it can make onboarding new hires as easy as sending an email.
With every patent application, there is a section called the claims. The claims are what we use to define the kind of the boundaries of what we consider to be the invention. And so, for instance, these, as I recall, Meta has an arrangement with Ray-Ban to provide AI-infused glasses, which are quite attractive. Actually, the ads I've seen makes me want to buy a pair as well. So when we claim something like that, the first thing we have to do is we have to understand what's already in the prior art. Prior art represents anything that was already disclosed to the public prior to the filing date of the application for instance, the Meta branded glasses. And so, for instance, you might remember 8, 9, 10 years ago, Google came out with something called Google Glass. And that was one that actually was on the market that people had heard about. But, a lot of times there's prior art out there that people applied for patents that they may never have actually commercialized the product. And so we try to get a good sense of what's already out there, what's already been disclosed to the public, whether in the form of publications or in the form of patent applications or issued patents. We then ask ourselves, how does the new thing, the Meta glasses, how does that differentiate itself from what's already in the prior art. But then we try to write claims that focus on those differences.
Yeah, no, very, very good. Do you think that the current legal frameworks are keeping up with the pace of these kind of technologies that they're supposed to govern? And if not, what do you see as the biggest gaps?
Yeah, I think that's a great question because right now, as I've mentioned, four primary categories in the United States for intellectual property: patents, trademarks, copyrights, trade secrets. Other countries also have a form of protection called utility models. Australia, for instance, has an Australia utility model legislation, and these are for inventions that are useful and important, but not necessarily terribly inventive. It's typically for a shorter period of time. It goes through a little bit lighter examination process. It's kind of an intermediate form of patent protection. I've sometimes wondered if the United States shouldn't adopt some sort of utility model concept for the protection of software and then only give it a 4 or 5 year term. Right now, a utility patent is good for 20 years from the date of the application's filing. Honestly, in the world of software, 20 years is maybe too long. I'm not sure that if software is ever terribly relevant 20 years after its introduction. Later versions of that same software might be relevant because of new features, but the original version maybe not. So I would like to see the United States at least examine the chance of introducing a new type of protection that would be focused just on software. And that would
Yeah, that makes
subsume also AI.
yeah, no, that makes a lot more sense, doesn't it?
Yeah.
So if I am correct, I understand that you're currently under consideration for a US Department of Commerce committee.
Yes.
Is that right? Yeah.
Yeah, my hopes are that will work out. Within the Department of Commerce, there are a number of committees, but there is one on advanced technology that I've been nominated for. Right now, the committee has 9 members. They're wanting to expand it next year to 15 members. They typically bring people in mostly from large companies, the Microsofts, Googles, IBMs, all have representatives. They're looking for people who have broad technical background and also some connection, hopefully, with venture capital, which I do. And the benefit of it is to meet regularly in DC, and then you have to make a report to Congress. And again, this should be relatively new. And ultimately, the Secretary of Commerce has got to approve me. So we'll find out hopefully within the next month or two.
Well, I wish you luck and congratulations on getting nominated.
Well, thank you. Yeah, it's exciting.
It's a big deal.
It's exciting. Like I said, I don't want to count my chickens before they hatch, so to speak. So
Sure,
you
sure.
see, hopefully it works out.
Yeah, indeed. So how do you see public policy influencing legal innovation and IP enforcement going forward?
Boy, that's a great question. I will tell you, because the Trump administration does want to compete effectively against all challengers, particularly China. You've already seen fallout over the last, from his first administration forward, in how he is dealing with innovation policy as it relates to China. Here are a couple little points. China does have a global view on advancing to first world status with regards to innovation. They have done that through, in many cases, inappropriate ways. Friends of mine who work for the Department of Energy, for instance, have told me horror stories of the number of Chinese nationals who have taken technology out of the Department of Energy, and in just the most blatant ways. You hear terrible stories about U.S. companies that set up joint ventures in China and under Chinese law are forced to kind of share and leave their technology behind. So if they pull out of the Chinese market, they leave a perpetual license to the technology with whoever their original partner was. Those sorts of techniques have been very effective. And what you see now is that China, in fact, has kind of moved to first world status as an innovator. You may not like the means by which they accomplished that, but they have accomplished it. And in fact, when you look at who's filing for patent applications in the United States, Chinese-based companies apply for more U.S. patents now than U.S. companies. So they have effectively tied, if not started to kind of pass us in certain technology fields. With regards to public policy, back to the kernel of your question, I think that it is clear that the U.S. appreciates that there are certain technologies that will drive economic growth in the near future. For instance, quantum computing is an area that you can see that the U.S. is wanting to promote, and you see that China is wanting to promote it, and they're doing it through different methods. But it will be one of those breakthrough technologies that will lead to rapid innovation in other areas. So public policy does affect intellectual property policy in the United States in that sense.
Yeah, indeed. And talking of Trump, I believe he's been in the news lately around the tax on patents. What's your view on that?
Boy, that's a crazy proposal. So the Trump administration and the Secretary of Commerce, Lutnick, have now proposed, and again, this is just in the early stages. They've not even put this out for public comment yet, but they've proposed a 1 to 5% basically property tax on patents. So in other words, let's say a patent was worth $1 million, we might have to pay $50,000 a year as a tax on the value of that patent. This is a I don't think a well thought through concept yet. Then again, I've only heard the headlines portion of it. I haven't seen the details. But first of all, it's hard to come up with the value of a patent. Unless it's being actively licensed or if it was recently sold, it's hard to say that we have a fair market value for any particular patent. Any one patent may be valuable on its own, but maybe it's only valuable as part of a larger group of patents. And so in isolation, maybe it doesn't have much value. So coming up with valuation is difficult. It's not like a used car where there's 10,000 other used cars just like it, and you can get a bunch of data and be within a couple $100 of the right answer. Almost by definition, every patent is on its own unique and its own unique value. So I think that is a first hurdle. The second struggle is patents already have an ongoing fee placed on them in the form of what we call maintenance fees. After a patent issues, you have to pay 3 maintenance fees to keep the patent valid for its entire life. And that, roughly speaking, $8,000 to $10,000 worth of fees already being placed on them. But it's predictable. You understand what it's going to be, and you can work that into your business model of how you're exploiting that patent. This might throw some real uncertainty into the sort of burden placed on a patent. I will mention a third problem with it, which is patents can fluctuate in value greatly. In other words, what may seem like a fantastic technology one year may very well be completely subverted by a new innovation by another company the next year, in which case its value may go from millions of dollars to zero overnight. I don't know how you adjust an annual tax when you're in a rapidly changing technology environment. So again, those are all hurdles that they'll have to think through with regards to this proposed property tax on patents. I'll throw out one other thing too, which is it's already a little unfair in the sense that, for instance, the Patent and Trademark Office is a self-funding organization. It doesn't take tax dollars. It's user fee funded. In other words, all the filing fees, these maintenance fees, that's what actually pays for the Patent Office's existence. Now it's going to be turned into a profit center. So I'm not so sure about that, but we'll see how that proposal evolves.
Indeed, yes. He likes to keep everybody on their toes, right?
He does, doesn't he?
Yes. So just looking ahead to the future, David, if you kind of look out to the next 5 years, what do you think are the kind of emerging technologies that you think will be most disruptive out there?
Well, certainly AI it will be hard to overlook its widespread ability to disrupt. I'm deeply concerned about its effect on employment, particularly entry-level white-collar jobs. We just simply see too many offerings that replace that sort of entry-level position. And I worry about the kids in college right now who are working hard in school only to find that the job they'd kind of hoped to use as their starting point is no longer available. It's been replaced. That said, I think there has to be a balance struck between job displacement from AI and job reintegration through universities. I think universities have got to evolve to be able to rapidly retrain young people back into skills that will allow them to become employable. And I think there's just going to be this weird balance between job displacement and new job integration that'll have to occur. Second thing, I'll throw this out just because I think it will be relevant, is in the blockchain field, I think that there is brand new business models that we're seeing that are implemented because of the blockchain that will displace current incumbent companies. I think when you look at the 500 largest companies, that list is going to greatly change, as some of those companies are simply going to be knocked out because their business model no longer works.
Yeah, no, indeed, it's going to be interesting to see it all unfold. To be honest,
Part of the strategy is to not be that company. Part of that strategy is to always be placing at least some bets on disruptive technology. Right now, blockchain and AI are probably the most likely to be the disruptive factors in destroying an existing company's business model.
Yeah, I agree. It's good and great advice. So just finally on this topic, if you could give one piece of strategic advice to tech founders or IP counsel navigating this shifting terrain, what would it be?
Gosh, understand the landscape you're getting into from an IP perspective. If you're a founder, and let's say that you've gotten $3 million of initial funding from some venture capital organization, the last thing you want to do is to spend that $3 million developing something that you later find out you're not allowed to make, use, or sell because the competitor already has it patented. The single worst thing you can do is to just assume that this great idea you have hasn't already been developed or thought about by somebody else. I've seen a number of examples of this happening where a company will come to us 2 years into its existence and then are shocked to find, oh my gosh, you mean there are patents in this field already? No, that would block me from being able to do something. What do I do now? Well, those are questions you should be asking early in the process, not late in the process. So
yeah, totally. Yeah, mate, it's very, very good advice.
Early understanding of your landscape, of your IP landscape.
Yeah. Good. So I just want to move to some wrap-up questions, if I may.
Sure.
The first of which being, if you could borrow Doctor Who's time machine and go back to yourself at age 18, what advice would you give yourself?
Well, that's a good question. At 18, what would I do differently? I would have spent a little more time doing computer science courses. While I had 3 or 4 as part of my engineering training, I wish I'd had more still. Especially, yes, computer software. I would have gone to business school a little sooner. That's the other thing. I found that when I got out, even out of law school, my understanding of just fundamentals of how to run a business were really pretty weak. Nothing that they really teach you in law school or engineering school. I might have considered doing a JD MBA combination. Instead, I waited almost 15 years before I did my MBA after law school. So, yes, more computer software, more computer architecture, and more business education.
Excellent. More degrees to add to the list.
Well, I tell you, as much as I've learned, what I really realize is that there's so much more that I don't know. Yeah, it's an old adage, but it really is true.
Yeah, no, it's fun to keep learning, right? It's the way to stay ahead. So yeah, no, I appreciate that. And just finally, what's keeping you inspired right now outside of the legal world?
Well, I'm starting to wear a second hat. I have started a venture capital fund called 5IR Funds. 5IR
Okay.
again for Fifth Industrial Revolution.
Mm.
We have seen such a growth in the number of patent filings in these fields, and we're starting to see the emergence of some great companies with really clever, disruptive ideas. And I've started a number of companies in my life, besides the law firm. Started a bank, started an innovation management platform. I decided to go ahead and bring in some partners, and we're in the process of raising $200 million. We've already made commitments to probably 6 companies that we've done a lot of due diligence on. Some in the AI space, some in the blockchain space, some in the VR space. We're evaluating one in the quantum space right now that we think is very exciting. That's what I'm very passionate about, because it ties in both sides in the sense that, again, I get to see some absolutely fantastic technologies. I'm always amazed by how clever people can be when confronted with a problem or an inefficiency, and they think about ways of changing that or overcoming it. And then, of course, if they can have a good management team in place that they can actually build a business, I think there can be some great returns for investors. Consequently, 5IR funds. That's something I'm very passionate about right now.
Yeah, it sounds really exciting. I appreciate you sharing that. Well, David, it's been fascinating talking to you and learning about IP strategy and what's happening in the future. I really appreciate your time today.
Thank you, Bim. I appreciate the time and the opportunity to be on your show.
We hope you enjoyed today's episode of The Legal Helm. Thank you as always for listening. If you enjoyed the show, please like and subscribe on iTunes or wherever you get your podcasts. It really helps us out.